Examiner's Report, UOL Contract Law. For this exam, candidates will have 3 hours and 15 minutes in which to answer the questions. Candidates must answer all parts of a question unless otherwise stated. Candidates must answer 4 of the 8 questions that they'll be shown. And here is a list of the permitted materials that can be brought into the exam room. 1 copy of course statutes on contract, tort and restitution. Disclaimer: the pronunciation of some of these names may vary. Alright, so question number 1 on this fast paper. Artem owns a business with 200 employees, including Bryony, Charles, Divi, and Ethan. Artem's bicycle is stolen from the bike shed at his business. On Monday, he sends an email to all his employees. Please help me look for my stolen bicycle. It is only worth £20, but is of sentimental value as it belonged to my dad. I will pay a reward of £200 to anyone who returns the bicycle to me or provides information that helps me locate it. On Wednesday, he decides to forget about his old bicycle and to buy a new one at the weekend, and so he pins a notice on the bike shed stating that his offer of a reward for the return of his bicycle is now withdrawn. On Friday afternoon, he also sends an email to all employees stating that the offer of a reward is withdrawn. Consider the following alternative circumstances. A. Bryony, an employee, is ill on Monday and Tuesday and does not come into work. However, she goes for a short walk and sees Artem's distinctive bicycle on a rubbish dump. She then returns it to him on Wednesday morning. Advice Bryony. B. Charles is a new employee and is keen to impress his boss. He takes Tuesday and Wednesday as holiday and searches for the bicycle, which he finds for sale in a second-hand shop. On Thursday, he goes into work and tells Artem where it is. Advice Charles. C. Davy learns from Freddie, a colleague, on Thursday about the notice Freddie has seen on the bike shed withdrawing the reward. That evening, when leaving a pub, Davy sees Artem's bicycle in a hedge and returns it to him the following morning. Advice Davy. D. While walking to work on Tuesday morning, Ethan sees the bicycle outside a shop where the thief has left it. He is riding it to work when he is overtaken by Artem in his Ferrari, who shouts, "I hope you are not after the reward. I've changed my mind." Ethan takes the bicycle to work and gives it to Artem, who refuses to give Ethan any reward. Advise Ethan. Now we are going to have examiners' response. Cases, reports, and other references the examiners would expect you to use. Identify at the start that it's a unilateral offer, referencing the Carlisle v. Smokeball Company case. In A, the issue is whether B is aware of the offer. If not, she can't claim. R v. Clark, Gibbons v. Proctor. In B, need to consider the effect of the purported withdrawal notice. Not as effective as email, so probably not valid. Shui. In C, there is actual notice of withdrawal via a third party, so D cannot claim Dickinson v. Dodds. Indeed, the issue is whether a unilateral offer can be withdrawn once performance has commenced. Refer to Errington v. Errington and Dahlia. Consider also whether such a term is implied when consideration is large. Luxor v. Cooper. A good answer to this question would often be relatively short but well structured, as outlined above, with each assertion supported by a relevant case or cases. Better students did well on Part D and were able to discuss the cases based on implied terms and the fact that E had embarked on performance. Poor answers to this question were often muddled and spent too long discussing offer and acceptance in general rather than focusing on reward cases. Showed confusion about how such offers are accepted and the different methods of withdrawal. The factual scenario was not read carefully enough or in detail, which led to incorrect answers to some subsections. Relevant case law reminders for this question. In R.V. Clark, Clark attempted to claim the reward of £1,000 for giving information that led to the conviction of a murderer. The trial judge dismissed the claim, holding that Clark did not rely upon the offer, nor did he intend to enter into a contract, stating Clark was never and never intended to be an informer. Clark could not claim the reward because it was necessary to act in reliance on an offer in order to accept it and therefore create a contract. When he gave the information, he had no intention of claiming the reward, and the offer was to the first person to give information leading to the arrest and conviction. Givens v. Proctor. Any advertisement which offers a reward for information which leads to the arrest or conviction of the perpetrator of a crime are to be treated as offers, as the intention to be bound is inferred from the fact that no further bargaining is expected to result from them. This case deals with whether or not a person who did not know of an offer can accept the offer if he or she completes the conditions of the offer. The court held that Clark would not claim the reward because it was necessary to act in reliance on an offer in order to accept it and therefore create a contract. Clark had not intended to accept the offer. Shui v. United States. After President Lincoln was assassinated, a reward of $25,000 was published for the apprehension of John H. Surratt, one of Booth's accomplices. Plaintiff aided in capture of Surratt. The reward had been withdrawn several months prior to Surratt's capture. In the newspaper, the U.S. paid $10,000 for plaintiff's assistance in capturing and identifying Surratt. The offer was revoked in a similar fashion that it was offered. The U.S. adequately compensated plaintiff with $15,000 for his assistance, as he did not actually apprehend Surratt as was required by the reward offer. Dickinson v. Dodds. Mr. Dodds wrote to the complainant, Mr. Dickinson, with an offer to sell his house to him for £800. He promised that he would keep this offer open to him until Friday. However, on the Thursday, Mr. Dodds accepted an offer from a third party and sold his house to him. Mr. Dickinson was going to accept this offer, but had not said anything to Mr. Dodds because he understood that he had until Friday. Mr. Dodds communicated that the offer had been withdrawn to a friend to the complainant. The court held that the statement made by Mr. Dodds was nothing more than a promise. There was no binding contract for Barrington v. Wood. Concerns agreement and the right to specific performance of an assurance that is relied upon. Barrington bought a house for his son and daughter-in-law. Barrington had paid £250 and the remaining £500 was to come from a mortgage paid off with 500 shillings a week by the newlyweds. Mr. Errington promised them they could stay in occupation as long as they paid the mortgage and that when all the installments were paid, it would be theirs. Errington died and the son left to move in with his mother. The mother sought possession from the daughter-in-law. The court held that the daughter-in-law did not have to move out of the house because she was entitled to stay and pay off the mortgage as part of a binding agreement with the father, and the claim for possession by the mother was dismissed. Dahlia Limited v. 4 Millbank Nominees Limited. An English contract law case concerning unilateral contracts and when embarking on the performance of an act for which an offer is open, at what point the offer may be withdrawn. The court held that there was a unilateral contract for disposition of land. There was no act of part performance which could lead to a binding contract.